The California Residential Purchase Agreement form is the cornerstone of every successful real estate transaction in the state of California. In this training video, we will review how to properly complete and use the RPA form step by step to better serve and protect yourself and your clients. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. We will cover paragraph 10. Our instructor for this video is Kevin Burke. Let's get started.
We're going to talk about paragraph number 10, and we're only going to talk about 10, and an hour and a half is not enough time. And if I tell you it's not enough time, you know that that means there's a lot in here, okay? So statutory, what does statutory mean? Statutory means that there's a statute. There's a law. There's a law that says you got to do these things, okay? And so I don't know a real estate agent out there. I know some brokers that know this, but there are a lot of real estate agents that don't know this. And I'm going to tell you, if it says statutory, that's a big word, okay? So statutory and other disclosures, okay? So statutory disclosure is disclosure required by law. So 1103.7, that's my NHD law, my National Hazard Disclosure Law, California Civil Code. California Civil Code 1102.3, that's my transfer disclosure statement. Okay, these are things that I get involved in when we're having troubles, when we're breaking the law, we're doing things we're not supposed to be doing, or we're doing the things we are supposed to be doing, which is my hope usually, because I can usually say, yes, you did it the right way, okay? So statutory and then other non-statutory disclosures, but then we're going to include in parentheses here, including lead-based paint hazard disclosure. So lead-based paint hazard disclosure is an EPA regulation. It is nationwide, okay? There are no exemptions to it, okay? It's a fairly broad topic. The penalty for failing to provide a lead-based paint hazard disclosure in a real estate transaction, whether it's a sale or a lease, the penalties are $10,000 per infraction, and that's a lot of money. And guess what? They don't care how many times, they're going to hit you for every one of them. Okay, so each one individually, separately, and so we're going to want to make sure that we do that. And so we teach you this in Real Estate 101, that my lead-based paint trigger is what year? 1978, right? So 1978, we triggered the lead-based paint. That's the EPA. That's when supposedly we stopped making lead-based paints. Doesn't mean we don't still have them out there. It's just we don't want you using them for residential purposes and things like that. And the damage that it does to children and all that, I mean, it's horrific. If you've ever seen anything as horrible as that, so it's a big deal. I think we should be doing that just for ourselves to make sure we're doing that. And it's the law, okay? So it's actually a regulation. So again, much like the commissioner's office doesn't create law, they issue regulations that have full force and effect of law, those kinds of things. So statutory and other disclosures, including lead-based paint and cancellation rights, if any. So now cancellation right, I want you to remember, cancellation rights attached to contract, okay? But rescission rights attached to statute. Okay, so most of you know to have a pen and paper or something where you can take notes. So when I talk about statutory, I'm talking about rescission. I can rescind the contract, make it go away like it never existed, put the parties back in the position that they were in when they first agreed to the contract, okay? Put everybody back where they were, make everybody whole, okay? Cancellation right, different thing. So rescission right, boom, easy one, okay? Cancellation, all right, we may have a lawsuit over that. We may have to argue that, have a judge, but boy, rescission rights, ouch, okay? It's a serious deal, okay? So let's take a look at what this is gonna do, and again, I'm watching my clock because I always worry about getting all this done because there's a lot to tell you. But let's take a look at paragraph number A1. Seller shall, within the time specified in paragraph 14A. So you remember 14A is my time periods, right? And A is the part where the seller has 7 days to give the buyer all these things, and we're looking at them right now, okay? Give the buyer all these things. B is the buyer's 17 days to do their due diligence. And by the way, those two run concurrently. So the 7 days is gone, the 17 days is 10 more days. So they run concurrently. So now we got paragraph 14A, important paragraph, delivered to the buyer. So the seller's going to give this to the buyer. What are they going to give them? Number one, if required by law, a fully completed federal lead-based paint disclosure. And you know what? It is required by law. What's my trigger year? 1978. So anything built prior to 1978. People ask me all the time, well, what about a remodel? So, hey, you know what? Listen, does it hurt you to do it anyway? Send it over anyway. I mean, if one piece of wood, and again, we know it's paint, right? But I'm probably going to make the disclosure. I'm probably going to use it in all situations where the property at any point was built prior to 1978. Okay, that's just how that's going to work. So lead-based paint and a pamphlet. So you do have an obligation still by law to disclose the possible existence of lead-based paints in properties built prior to 1978. But in California, you must also, in all transactions, give them environmental hazards disclosures. Okay, and so usually we accomplish that. The seller accomplishes that with the natural hazard disclosure. Companies that are out there, they normally provide that for you. But remember, there's a free handbook from the California Association of Realtors has that's available for you that you can use, and it's also in your Zip Forms program. Okay, under your environmental program on the right-hand side, under forms where you can pull those up. We include those in all of our transactions. We don't care in rentals, all that stuff. So don't fall prey to that. Okay. Number two, let me erase number one really quick. So number two, unless exempt. So the first one says if required by law, and the answer is pre-1978 federal lead-based paint for sure. Okay, number two, unless exempt, fully completed disclosures or notices required by what? 1102. We talked about that a little bit earlier. California Civil Code 1102.3, right? And then 1103. So 1102, remember, was my TDS, and my 1103 is my NHD, okay? So that's what those two are. You don't need to memorize these terms. You just need to know that these are important things, okay? So of the Civil Code, of course, I just said that. Those are called statutory disclosures. They include but are not limited to, so the lawyers wrote that, include but not limited to a TDS, here it is, an NHD, notice or actual knowledge of release of illegal controlled substance, like methamphetamine, so an MCN disclosure, methamphetamine contamination notice. Okay, notice of so now these are things you have to do. These are statutory. These mean that until the seller gives the buyer these things, the buyer's got a right to rescind the contract, and we're going to get into this in just a second. I love this paragraph. It's got so much good stuff in it. Okay, notice of special tax. What is that? We call special tax. Oh, I'm sorry. Melrose is not a tax, right? I'm just leaving that there for you to think about that for a minute. It is a tax, right? But they can't call it a tax because then it would violate Prop 13. So it's a special assessment, right? So it's a way to avoid calling it a tax so that they can raise some more money, okay? Or if allowed, substantially equivalent notice regarding Melrose Community Facilities Act, okay? So that's our way to fund schools, police protection, fire, parks, streets, lighting, things like that. Those are all the things that normally would be included in your taxes, but it's a convoluted kind of thing. The bottom line is just you realize we're passing it on to you as a separate assessment. Okay, all right, so I won't get into that because that's a whole nother class. Okay, so an Improvement Bond Act of 1915, and if the seller has actual knowledge of industrial use and military ordnance location. So, those are really important things for us because, we have a lot of places, Coronado, Tierra Santa, Oceanside. We have places in San Diego County with stuff that hasn't gone boom yet, right? So in other words, unexploited ordnance. Ordnance is ORDNANCE. There's no I in there. Okay, ordnance, it goes boom. And so we lose children, a real tragedy. They pick stuff up. I mean, it's not all over San Diego County. I would just assume that it is. San Diego is real special in that way that we have stuff that are not common in other places, but just be aware that if you are near something like that, we must make that disclosure. Here's my ordinance, okay? And then we have two forms for that. One's my SPQ or my ESD. So my SPQ is my seller property questionnaire. And then my ESD is my exempt seller disclosure. So the ESD is only used in those situations where the seller is statutorily exempt from providing a TDS. And if they are, and that there's only 4. And so you look it up because it's good, okay? So it's not what people think it is. A lot of people think it's banks and stuff like that. No, it's not true necessarily, okay? They have exemptions if they're the holder of paper only. So when they take a property back, as long as they turn around and sell it, they don't use it as a rental. We had a really ugly case in Coronado, North Island, many years ago where a bank took back a property and then continued to collect rents from tenants. Okay, guess what? Court held that they became an owner and it became, a Superfund site. So just be aware of that. So my SPQ, as a matter of fact, I did pull these forms up for you so that we can take a look at those. So let's take a look. I'm going to knock this out here right now. And thank you. We've got more people joining. So here's my TDS. This is my, okay, can you see this? Yes, you can. Okay. So here's my TDS. It is my transfer disclosure statement. You will notice on the TDS, it says Civil Code 1102. Et sequitur means and following. So it's going to be 1102.3, 0.4, 0.5. Okay. And this is the transfer disclosure statement. This is one of the most powerful disclosure statements, one of the most powerful documents in California as far as the seller's requirement of disclosing. This is a form that is in the statute. If you go to Civil Code 1102, you will see this form. It won't have my logo on it. It won't have the California Association of Realtors on it. But when you go there, you'll see the form. And so what we did is we took a picture of the form and we put it on our letterhead. So essentially, California Association of Realtors, they understand that you may not create your own form. You may not deviate from this form. This is a statutorily required document, okay? Let's look at my last upgrade. April of 14, all right? And so when I go through it, I'm not going to do a class on it here today, but we did a really good webinar on this, and I think we need to do another one, but it was about 3 months ago. I think we need to do another one. TDS is a powerful, powerful thing. And by the way, your Glide program, which SDAR has funded for you, you can have the seller fill this out online. So rather than having them fill it out, print it, fill it out, that kind of thing. So the Glide program, keep your heads up on that. We did a webinar on that about a week ago. So go take a look at that. It shows how you do all this stuff. You send it to the seller, they fill it out. This is my transfer disclosure statement. Page 1 and 2 belong to the seller, okay, in the shortfall. Page 3 belongs to us, okay? Page 3, towards the top of the page, paragraph number 3 is going to be the listing agent's disclosure. Number 4 is going to be the buyer's agent's disclosure. Number 5 is going to be, we've got copies of everything above. I see most commonly I'll get one of these where the seller has already signed this and the listing agent has already signed it, but the buyer's agent hasn't filled out their portion yet. So guess what? Yeah, you need to get them to sign it again. It's a statutory form. Okay. And by the way, your agent's visual disclosure is not statutorily required. But in my conversation with Veronica Kilpatrick, Deputy Commissioner, I love Veronica, and she says, we think it's probably good, something you should be using because you need to be able to document the fact that you actually physically visited the property. So not required by law. The AVID is not required by law. It just makes really good sense. I would do one. Your broker probably requires it. I can't imagine you going to a property and saying, I couldn't find anything, to note on the disclosure. It doesn't mean wrong. It just means items to note, okay? If you can't figure it out, you let me know. I'll help you, okay? Because you need to know how to do this, all right? But then bottom line again, how can you have your seller and the listing agent sign down here if they haven't received paragraph number 4 from the buyer's agent, okay? Everybody good with that? Okay, so that being said, let me also take a look. I want to show you my next form, which I can't see. Oh, there it is, my seller property questionnaire, so we can get this out of the way. So the TDS itself was created by the legislature. Okay, so congressmen, they created the TDS in California, all right? So do they do real estate? Brian Jones does. Brian Jones is a real estate person. I love Brian. And you know what? But they all created that, but they didn't get enough input from him. And so you have a form put together by bureaucrats rather than a form put together by real estate agents. So what do? We say, okay, the TDS is a really good start, but I'm going to lay right down next to it. I'm going to take the TDS, and right next to it, I'm going to lay down the SPQ, and I'm going to go ahead, and the SPQ is designed to fix the things that were missed in the TDS. So if you take a look at it, it doesn't duplicate it. It just goes in and pries deeper. We call that unpeeling the onion. That's what we do as real estate agents. You notice how, some of the stuff we don't have to address, others we do. And that's what your SPQ is all about. So your SPQ, otherwise known as your seller property questionnaire, obviously quite a few pages long, 4 pages long of stuff that was not covered by the 3-page TDS, okay? Now, so the SPQ was created by the California Association of Realtors. It was really a copy of the seller's additional disclosures, which came out of your risk management department at the San Diego Association of Realtors. So some of the brightest real estate attorneys in the industry put together a form called a seller's additional disclosures, and we were updating it, doing all that kind of stuff. And California said, hey, wow, that's really cool. We're going to, kind of use that across the state, which they did. They went ahead and did that. And we went, okay, we had to look at whether or not we wanted to get involved in a controversy with them. And then we decided, all right, you know what? We're going to let you have our form. But in the meantime, we're going to go out and we're going to create another form that is going to complement that. So what I said a minute ago, I said, I take my TDS, I put it down on the table, I put the SPQ next to it. That's the statewide form. And then I look at the seller property questionnaire addendum, the SPQA, and I put that next to the SPQ. You'll notice it starts on paragraph number 5. Okay, so in other words, this is the stuff that was missed in the SPQ, which was the stuff that was missed in the TDS. Okay, so in other words, we want to make sure the seller is making full disclosure. If there's going to be litigation, it's going to be because of a failure to disclose, lack of disclosure. Okay, and that's important to you. It's important to me. Certainly, the buyer. It's going to be important to the buyer. So let's make sure that we get all 3 of these forms when we're doing a real estate transaction. Okay, everybody with me on that? Those are important things. So again, those are the TDS is statutory. So therefore rescission rights attached to that. The SPQ and the SPQA are contractual. The SPQ is contractual. It's automatically contained in the purchase agreement. There was a big fight about that, but we decided, no, we're going to make that. You got to have that in the transaction. And then for us, in our office at least, and in most of the brokerages, it is the standard of care in San Diego County. We included in our purchase agreement under paragraph number 5, under addenda and advisories, we do SDAR forms, APA, LAD, and SPQA. So we add that to the contract so that now I have linking to all 3 documents. Everybody good? Okay. All right. So that was A. I told you there's plenty to talk about. Okay. All right. So that's part of A. So we got into, nope, that's all of A. Okay. Let's talk about number 2 then. Whoops. First of all, let me check, see any questions. I always wonder if I'm like putting everybody to sleep, but hopefully I'm not. Okay. So let's talk about A2. Any statutory disclosure required by this paragraph, okay, by this paragraph is considered fully completed if the seller has answered all questions and completed and signed the seller's section, and the seller's agent, listing agent, if any, has completed and signed the seller's brokerage firm section, or if applicable, an avid. Okay, so it is not complete until you have all of that. And so if you check the box that says avid, and I get into this confrontation with TCs all the time, the avid is not required, but if you have checked the box that says that you're going to include one, then you need to include one. So is it not complete until then? And the answer is right here in this paragraph. It is not complete until you get the listing agent section as well. Okay. Again, it's going to stop at listing agent. It's complete at that point. Now it gets delivered to the buyer. The buyer has 3 days to look at the contract or to review it and see if they have a problem with it. So I'm going to dig into this a little bit deeper in a second. This is the big issue. Okay. All right. Nothing stated herein relieves a buyer's brokerage firm, if any, from the obligation to do the following. So remember, the statutory purpose is completed with the seller and the listing agent, but now the buyer's agent has to do what? Also has to do a reasonably competent, diligent visual inspection of the accessible areas of the property and disclose, on section 4 of the TDS, we just talked about that, or an avid. Okay, material facts, the material facts affecting the value or desirability of the property that were or should have been revealed by such an inspection. So in other words, if you just, your only obligation as a real estate agent is to inspect, not to investigate. Remember, the buyer's obligation is to investigate the property and determine its value for them. But your obligation is only to do a reasonably competent, diligent visual inspection of the premises, right out of the Strasburger case. Okay. All right. Okay. By such inspection, or number 2, complete any sections on all disclosures required to be completed by the buyer's brokerage firm. So if your broker tells you got to have certain stuff done, let's just assume that they've already talked to counsel and that counsel says, yeah, you need to be doing these things. Okay. You're going to have to trust your broker. Okay. All right. So everybody got that so far? So, what does this do? This says I need the seller to complete their section. I need the listing agent to complete their section, including an avid if they check the box for avid, and then we can march on from there. Okay. At that point, once it's delivered to the buyer's agent, and this is a problem that we have had over the years, is that a lot of times the buyer's agent would hang on to the transfer disclosure statement and maybe not give it to the buyer right away, but not return it to the listing agent seller, thinking that would extend the time period. Remember, buyer only has 3 days from receipt to decide if they're going to have a problem or not, and we're going to see a really cool exception to that in just a second. Okay, and then finally down here in bold print, note to buyer and seller, you may not waive statutory and lead disclosures. Okay, so up here, statutory and lead-based paint disclosures, you can't waive those. It's prohibited by law. All right. So, don't let me see a document that says everybody, we're all going to agree to waive that. No, you don't waive that. Okay. That's not something you can waive. It's against the law to waive it. Everybody good? Questions? Good. Seeing none, let's go to the next one. Okay. So paragraph number 4 now. So I'm under 10A4. And in this one, within the time specified in paragraph 14A, seller, unless exempt from the obligation to provide a TDS. So remember, if exempt from a TDS, then they have to fill out the ESD, right? The exempt seller disclosure, shall complete and provide buyer with a seller property questionnaire addendum. There it is. If the seller is not required to provide a TDS, seller shall complete and provide with the buyer with an ESD or an exempt seller disclosure. Everybody good? Okay, so if they are exempt, TDS exempt, and listen, the decision as to whether or not a seller is TDS exempt is a legal one. Okay, so remember, you don't want to be part of that. If the seller says I'm exempt, you're not there to agree or not agree. That's legal advice. Okay, so in our office, whenever we write an offer and the other agent says we're exempt, remember the agent's never exempt. Agent is subject to Civil Code 2079, but the seller may be exempt, but we don't know. We can't say that they are, that they aren't. So we're going to make repeated requests to get that form. And James, you asked me in a previous webinar, we're going to request it, even though they said that they're exempt. They're going to come back and say, we're exempt. I'm going to send another request a couple days later. They're going to come back and they're going to say, hey, stupid, I told you we're exempt. And then the third time I'm going to do it, they're going to come back with some kind of nasty thing. I'm going to have my buyer sign a blank form. I'm not going to fill any of it out. I'm going to have the buyer sign a blank form, and then I'm going to provide an avid. Okay, and that was why that paragraph earlier referenced that the buyer's agent can provide just an avid. Okay, let's take a look at number 5. Buyer shall, within the time specified in 14B1. So remember, that's the buyer section. 14A was the seller section. Okay, here's section 14A is seller. 14B1 is the buyer. There's the buyer. Okay, return. So the time period specified, 17 days, shall return signed copies of the statutory lead and other disclosures to the seller. So I had an interesting conversation with the TC who said, we got 17 days to return all that. And my response was, I gave it to you at the time of the offer, and you're going to see in a second how come that's going to trump everything, certainly that the TC says, no offense to the TC. But you know what? Yeah, you don't have to return it, but the buyer may be giving up rights by you hanging on to it. So you remember, once it's delivered, once I've got the listing, I'm the seller and the listing agent completing the TDS, and it's delivered to the buyer's agent, whatever, then there may be a 3-day right to rescind that may go, you wait in 17 days, it's too late, right? Okay, all right. So number 6, let's take a look at number 6. In the event the seller or the seller's brokerage firm prior to closing becomes aware, now this is what we're going to call our duty to amend, okay? Becomes aware of adverse conditions materially affecting the property, okay? So all of a sudden something new came up after the disclosure, all right? Or any material inaccuracy in disclosures previously provided to the buyer, the seller shall promptly provide a subsequent or amended disclosure or notice. So again, this is what the law refers to as a duty to amend, which means something new happened that you didn't tell them the first time. Now you got to tell them again. And by the way, that might trigger that rescission right again. Okay. And that's an important thing. All right. So in writing, okay, covering those items, okay? And then now, so I made that point clear. I want to show you now what happens where a subsequent or amended disclosure shall not be required for conditions and material inaccuracies of which the buyer is otherwise aware. So in other words, they do a physical inspection, they have a manometer reading, they have a geo, they have something done to the property. So something else that triggers the buyer's awareness does not trigger the right to rescind. It may trigger a contractual right to cancel, but not the right to rescind. And remember, as we said in the very beginning, rescission is a very powerful word of law. It says put the parties back where they were before the contract, and everybody goes away, okay? All right. Which are disclosed, here it is, which are disclosed in reports provided to or obtained by the buyer or ordered and paid for by the buyer. So the buyer discovers new things. It does not trigger this, the Civil Code 1102.3 right to rescind the contract. It just says that the buyer has learned new things, which may give them rights under the contract to cancel, but it doesn't give them the right to rescind the contract, okay? Rescission, again, being very powerful. It says, you know, give them back their money, let them go away. You know, this is a very charged legal issue. We might get into a legal battle over a contractual right to cancel, but it's not as likely to happen in a rescission right or statutory right. Okay. Paragraph number 7. If any disclosure or notice specified in 10A1, okay, up here at the beginning of the paragraph, or subsequent or amended disclosure or notices to deliver to the buyer after the offer is signed. Now, this is my most favorite thing. This is what I tell you. I say, listen, if you give the buyer all of the statutory disclosures before the buyer commits to the contract, then the buyer doesn't have a 3-day right to rescind. The law says, you know what? You already had all the disclosures. You decided to move forward after you knew all those things, so you don't get another 3 days. Okay, it's not going to happen. You got it at the time of the offer. Okay, that's why in our office, you know, when we take a listing, we get all the disclosures signed on the listing appointment, get everything done, ready to go, order the NHD, do all that stuff, and then when the buyer's offer comes in, we shoot all that out to the buyer's agent, and guess what? Now you've got the offer clearly, and you've got all the disclosures, excuse me, as well. So now it's called a wrap. Okay, you got nowhere to go. You know, you knew at the time that you signed the counter offer that you had all the disclosures in front of you. Okay, so any of these things, buyer shall have the right to cancel this agreement. So anytime after the offer is signed, buyer and seller come together on the offer, buyer shall have the right to cancel this agreement within 3 days. So in other words, 3 days if they didn't get it at the time before they committed to the offer. Okay, follow me? So a lot of us think, oh no, they've got 3 days. You know, they got 3 days to cancel from the time they open up the contract. It's like, no. You got all that stuff. This very clearly says that only when the offer, when the disclosures come in after the offer is signed, and again, when we say offer, we mean buyer, seller, delivery, you know, all that, within 3 days after delivery in person or 5 days after delivery by deposit in the mail, which none of us do that anymore, or an electronic record satisfying the UETA by giving written notice of cancellation to the seller or seller's agent. So again, you have an obligation to give express cancellation or express rescission of the contract, but only in that situation. You know, so in other words, if you got all the disclosures, why would you sign the contract? If there's something in the disclosures that you don't like, then you shouldn't be buying the house, right? Instead of trying to fall back on it later. Everybody good with that? Very, very powerful statement, okay? Okay, good. All right, that being said, no questions. Okay, all right. We're killing it here. We're gonna go to the next page. I'm doing pretty good on time. I might actually get this done before midnight. Okay, so let's talk about paragraph B. Okay, so we went from A, now we're in B, and we're going to talk about one of my favorite subjects, which is natural and environmental hazard disclosures. Okay, so this is going to be number B right here. So natural and environmental hazard disclosures. So you all know back in 1992, they created this law that said that sellers had to disclose to buyers whether or not the property falls within 6 zones specified by the state of California. So question, are different counties in our state governed differently with regards to disclosures? And San Jose Realtors asked me prior to viewing the home for disclosures. So, and that's true. In the Bay Area, it's not contradicting what I just said. In the Bay Area, they give you all the disclosures, but then they also have what's called a disclosure packet. So I know because we do business in San Francisco, so they have what's referred to as a disclosure packet. And most of the agents will give you that packet at the time before you even write your offer when you're showing the property. And that's what they're referring to. But once again, if you've got the listing, you should already have the seller fill out all the disclosures. Okay, and you should provide that to the buyer. But what they're referring to is a specific packet that is produced by that area. So that's a great question, Julie. So they're not governed differently. It's just they have additional disclosures, and those disclosures are normally given. So, like for example, we took a listing up there. We have brokers all over the state of California, and this broker happens to be a broker with us and happens to be an attorney. And so at the time of the listing, we learned very quickly that we needed to get that disclosure packet. And so you order it, it's available from the city or the county, and they'll create the packet for you. It takes them a couple of days to get it to you. And once you get it, you just forward that on to the buyer and everybody signs it. Okay. So great question there, Julie. And Veronica has said, if you're doing transactions, if you're a San Diego real estate agent, you're doing transactions in Temecula, you might be operating outside your field of expertise. And I think what she meant when she said that was, are you familiar with the disclosure requirements in that area? Orange County, are you familiar with the trellis disclosures, things like that. So, make sure that wherever you decide, your license says California, you can do real estate in California, but the question is whether or not you are going to be compliant with the rules that are going to be in that area. So the optimal time to deliver disclosures to the buyers along with the seller's counteroffer. Absolutely, James. Yeah, we love it. That's what we do here. We just go ahead. We get all the disclosures signed by the seller. Listen, it's part of earning our medal, as we say, right? So a lot of times, agents will go in on a listing appointment, they'll bring in the listing agreement, and next week, by the way, we're going to be doing the winning listing presentation again. It'll obviously vary a little bit from the one we did a month ago, but we come in with all the disclosures. First thing we ever have the seller sign is all the disclosures. The very first form that's ever signed is that RA form, my Realtor Acknowledgement form. I sign that in front of the seller. I push it across the table. I hand it to them. I say, look, no blood. Right. And that's, I'm a little showman when it comes to that, but we're here to sign things. We're here to do stuff. And so let's get to it. All they want to know, how much are you going to charge me, or how much are you going to make? How much am I going to, you're going to sell my property for, and how much are you going to charge me to get there? Those are the two things they want. Okay. Well, I give that to them at the end of the conversation because that's all they want to talk about. Let's get all the disclosures out of the way. By the time you are done with me going through the disclosures, you realize, wow, there's more to this. So the other agent that came in with a listing agreement, all they had was just the one document, 3-4 pages, that one document, they're doing themselves a disservice. They need to be there and show their professionalism and bring everything to the table because of what we're learning right here. If I can get all those disclosures created at the time of the listing, then I have a package to give the buyer when the offer comes in. So to answer your question, long answer to short question. Yeah, I'm going to give everything when the counter offer goes over. So I'm the listing agent, counter offer goes over to the buyer's agent. I'm going to send the whole package of disclosures along with it, right? Because guess what? Your buyer's going to get, there it is. You got a chance to read it. You're going to decide whether to move forward or not, knowing all the bad stuff there is about the property. The seller's going to make their disclosures, all that stuff. So, I just love doing it that way. And guess what? I don't explain to the agent, we're doing a class here, but I don't explain to the agent, your buyer's going to lose their right to rescind the contract. And I'm not doing that. You call your lawyer, let them tell you. Okay. So great question, James. Thank you. Always thank you. Julie, Do you think that our county should start providing disclosures prior to offers being written? Absolutely. Absolutely. Please. Will all of you here that are in this today, would you agree with me that from now on, when you take a listing, you get all the disclosures signed? I mean, how much is it? It's TDS, SPQ, SPQA, get your Ferpa. You know, we've got, you know, all of these things, it's not that much. And so, yes, I think you need to get those things done. When we do the winning listing presentation next week, I'm going to show you, here's all the forms. You know, this is what my appointment looks like. And I don't care if you're doing it online. If you're doing it online, if you're emailing it to stuff, you need to be on the phone with the client, talking to the client when they're looking over the paperwork. Don't just send them stuff and say, here you go, you know, let me know if you have any questions, you know, and then you get back, something's not even complete, right? Okay. I had a lawsuit a year ago where the seller missed a paragraph in the SPQ. They missed paragraph number K in the SPQ. And so, you know, buyer sued over it. And so well, we were successful in trial, of course, but, you know, at the end of the day, missing that one paragraph, you know, they provided the contractual disclosure, which was the SPQ. They clearly provided the TDS, all those things, but those kinds of things are going to set you free. Okay. But y'all got to agree with me, please. Let's raise the bar on everybody else. When you go on a listing appointment, okay, take that packet with you. If you are going to do it, and again, winning listing presentation next week, we're going to kill it. Okay. So I get every listing. I get every listing I want to get. Okay. I may get there and decide I don't want it, or I just might not get along with the seller. Okay. But, you know, I'm pretty good. I can get along with most personalities, right? There's very few times when I've said, you know, this ain't going to work out. I have had that happen where I tried to walk out of a meeting and the seller turned to me and said, where are you going? I said, I don't think it's going to work. And I go, wait a minute. You know, so, you know, by that point, I'd already earned my medal, as we say. And so, you know, please be professional. Take this stuff with you. Don't be afraid of it. All that stuff is going to improve your chances of getting the listing, improve the chances of getting it at the right price, because now you're a professional, not just somebody trying to get a listing, right? Now you're a professional. Let's go over the disclosures. So if you've read them and you know how to explain them, you know, the seller's not seen this before. Right? Remember, you're selling houses every day, hypothetically. I was telling them earlier this morning, I got in trouble with DocuSign because we had like just short of 1,000 transactions that we did last year. And they said, you bought the broker version of DocuSign, but we really kind of only budgeted that you would do 200 transactions. It's like 200, boring. Okay. So let's get those numbers up. Okay. I want to see you get your listing. All right. I mean, get the ones you want. Okay. All right. So Julie, thank you. Great comment. Yeah. Get those disclosures in the beginning. You know, I'm going to spend hours with the seller. And by the way, if you're doing it electronically, you still need to spend time with a seller. My advice, in Zip Forms, they have a program that's right up there at the top on the far right-hand side of the screen that says it's any meeting, I think, or go-to meeting, and it's free. You can go right in there, get the seller on the horn. They can follow along. You know, you can show them, open your Zip Forms program up. They can follow along as you're doing that. It's a great little program. Nobody uses it. You know, everybody's using Zoom. Well, you know, what the heck? You only got 40 minutes on the free version, and it's not encrypted. So it's not encrypted on a lot of levels. I'd be really careful with Zoom. And here we are, right? There's more risk to me, by the way, as the presenter than there is to you as the recipient. So, so Julie, thank you. Great question. I'm going to just take that ball and run with it, okay? James, thank you, buddy. Awesome information. Pamela, oh, yeah, agree, right? So, you know, it is really great stuff. When you prepare a listing date agreement, does date prepared start? And the answer is yeah. So when I'm preparing the agreement, that's date prepared. So that's in the upper right or upper left-hand corner. I got to remember I'm backwards. So upper left-hand corner, date prepared is when I prepared it, not when they sign it. Okay. And then also, by the way, the listing period. So like we did a listing the other day, we prepared the listing on the 29th of May, and we had this, and so it said date prepared 29 May. And then the listing period was 1 June to 31 August, right? So the date prepared is just the date we put it together. And then the term is going to be most of us try to start at the same day. Well, it can start on another day. The only risk that we would have had would have been within that 2-day period, that the seller might have, sold it to somebody else. So, and then the day that they sign it's completely different. So it doesn't matter. Okay. So great question, Pamela. Julie, do you think moving forward, should we then in San Diego provide those disclosures to buyer's agents prior to their submission of the offer? Absolutely. Well, no, here's the thing. When they send over the offer, I mean, how many times have you not seen a counter offer? It's almost always listing agents looking around for something to do, right? I mean, it's like, even if it's a perfect offer, and I don't think I've ever seen one of those, other than the ones I write, but you know, I have had offers accepted with no counter offer, but I think most of us in our experience are expecting a counter offer. So when I'm the listing agent and I get an offer on a property, I go through that offer line by line with my seller, and I explain to them, these are the things that I've got issues with. You know, they may be important to you, maybe not. Let me know if you want to do anything about it. And then, oh, by the way, and we covered this in our seller counter or our counter offer class that we did last week. We did counter offers, mobile counter offers, and backup offers. And so we covered that. But essentially, you know, we go over that, and then as the seller signs the counter, off go all the disclosures in the same packet, Julie. Put them all, get them all out there. And so you had done that before the offer has been accepted, and that's what this paragraph is all about. Great questions. Great questions. Thank you. I think it could weed out a lot of buyers in a beneficial way. So great question. So like, for example, in our listing on Mission Boulevard in PV, our agent put in the document section the PED, right, the PEAD visitor, and the PRE posting the notice that's required now by law, as well as posting it at the property. We just got it everywhere. Do you put the TDS in there? And so question is, TDS, SPQ, SPQA, you're putting that out. You know, the world doesn't see the documents, but an agent that looks at the listing can see the documents. And so, you know, maybe you put the TDS in there. I don't know. Talk to your broker about whether or not that's going to be something that you want to do. But remember, when you put it in there, it's in there. You can always delete it, but there it is available. So we put in the confidential remarks, please see attached documents for disclosures. And so that's what they do. They go in there. So great question, Julie. And definitely in a beneficial way. You know, your buyer, listen, if your buyer has a problem with the fact that you know, they can't bring their pet llama to the property, you know, then let's get rid of them early, okay? Or else get rid of the llama, okay? All right. I always use that as a joke, right? Because most people's pets are not quite as big as a llama, you know, but I see so many times where people put in the listing, oh yeah, pets are allowed. Not my pet. I got a pet llama, right? A big one, okay? I don't really have a llama, but I use that as an example. Pets are not, you know, there's no such thing as a place that doesn't have some kind of pet restriction, unless it's a place called a zoo, and I don't think that qualifies. Okay, can we prepare blank documents, like without a property and name attached? The answer is yes, you can. You can prepare blank documents. I don't know what your intention is. Let me know what your intention is, and I can let you know the workaround of that. But yeah, you can. The reason we don't allow you in zip forms to create blank documents, you know, something without an address, is because we worry about the people copying it. So we've actually had, you know, websites where people are telling people, hey, you don't need to, you know, work with a realtor. Here's the forms, and so they actually post our forms up on the internet, and it's like, no. And so for the people to print it and do all that, no. First of all, they don't have any protection, but whole nother issue. Jane, when a listing agreement was prepared on 6/1, but seller signed it on 6/4, in the MLS, do we use 6/1 or 6/4? Well, if the seller doesn't sign it until 6/1 or 6/4, I'm going to tell you that you don't have a listing until the 4th. I would probably put in 6/4 as the listing date, but here's the problem. So, you know, you didn't have a listing until then. Okay, and so on 6/4, now you've got a listing because that's when they signed it. So I would put in that would probably be the date. You can defend that, and I'm happy to take that case for you. But what normally, I'm the chair of the rules committee, but you know what happens? It does happen, right? Where the seller doesn't sign the agreement until later, and then when they sign it, I've lost market time. Just remember that if the MLS calls you up and says, send us a copy of the listing agreement, I want those numbers to match. Right? Don't add 3 more days to the expiration period, because that's not what your contract says. Okay, and that's the temptation, is to do that. The temptation is to add 3 more days to the end because you got it 3 days into the listing period. Don't do that. Okay, if they ask you for a copy of that agreement, not a good time to start doing forgery. Okay, get them a copy of the agreement. All right, they're there to help you. They're an educational service. We're not really looking to ticket people, but If you have a question about it, you can certainly send an email to rules@sdmls.com. Some of the nicest people, Roland, I love Roland, Dana. I mean, you know, we just have some of the most wonderful people there, and they're here to answer your questions, not to give you grief. Okay. Agency disclosures, absolutely. Agency disclosures always before the seller signs a listing agreement, before the buyer signs a buyer representation agreement, but certainly before they write an offer. Okay. Remember that in most states, before you have a substantive conversation with the client, you need to have that done. Okay. So they walk in open house and ask you how the weather is. You don't need an agency disclosure for that. But once you start talking to them about property, you need an agency disclosure. Okay. Can't create blank and zip forms. Yes, you can. Hit me offline on that. Okay. Good. All right. You're not supposed to. And again, I'm telling you why, is because people copy our forms and we don't want to do that. And so we changed the way that you can do it from time to time because of bad guys. And I'm assuming you're not going to be a bad guy. So let's take a look at my national environmental hazards. Remember I said 1103.7, right? So within the time specified in 14A, there I go again, seller's requirement within 7 days or other, if you filled in a different time, seller's requirement, seller shall, if required by law, and they are, okay, by law, 1, deliver to the buyer earthquake guide and questionnaire, environmental hazards booklet, and home energy rating pamphlet, okay? Now you have those available for you in zip forms, okay? But I'm going to show you in a second why you might not want to do that, okay? So it has all that stuff. Number 2, disclose if the property is located in a, here we go, here's my 6 zones: special flood hazard area, potential flooding inundation area, very high fire hazard zone, state fire responsibility area, earthquake fault zone, seismic hazard zone. Okay, so I've got, what have I got in there? I used to have this memorized with, you know, I have 3 earthquake and 3 flood, right? No, anyway, sorry, I shouldn't have gone there. I used to have a little thing to help you remember it, but now I've forgotten it. Obviously it didn't work. Okay, I can look at it. So what, 1, 2, you have 2 flood, 2 fire, and 2 earthquake. That's what it is. Okay, bingo, I got it back. That was easy. You read the document. Number 3, disclose any other zone as required by law and provide any other information required for those zones. So in the state of California, in zip forms, we have a form called the Nhd Form. It has gone through a lot of adjustments since it first came out. When it first came out, it said in the document, and again, this is another one like the TDS, take a picture of it in the Civil Code, 1103.7, took a picture of it, put it on California Association of Realtors letterhead, put it in the zip forms, but it said in the document that the listing agent certified that the information provided by the seller was correct. Okay, God, we went crazy about that. 6 months, we argued with the legislators that created the form, and we said, hey, come on, we can't certify that any more than the seller can. So what we did was we changed the form at one point, and now the language is much calmer. But what most of us do is we're trained to hire a third party to do the disclosure on behalf of the seller. So, you know, that third party sometimes, you know, there's some really good ones out there. They're going to take the heat for the mistake, because in court, the damages for not telling the buyer that it's in, for example, an earthquake fault zone. Some people think, oh, I've never felt an earthquake. It's not in the earthquake fault zone. So, but you might be in the zone as mapped by the state of California. And by the way, some of the zones have never been mapped. Okay, so doing it incorrectly, most times the seller wanted to just do, I don't know, I don't know. The statute didn't allow for that. Statute said you got to tell the buyer. And so rather than take responsibility for it, in our office, I don't advise using the form, because now the seller is the one who's going to be on the hook. And what are the damages for incorrectly noting that a property is not in the zone? So the courts hold that it is the cost of the property. So the buyer paid $1 million for the place. Guess what? It's $1 million. Okay? Because what? You can't move the property out of the zone, right? You can't. So that's the damages are going to be, and damages, again, term of law, be careful. Okay, damages are going to be the value of the property. You can't move it out of the zone. So the damage is done. And when does the buyer discover things? It's always after the closing, you know, that kind of thing. So my advice is I would use a third party. We've actually had a couple of those companies come in and speak to our risk management department. And some of them are disclosing a lot more than they need to disclose, you know, because it's just a 6. right? But those 6 are all covered on page 1 of that NHD. And then some of them are doing other things like red-legged tree frogs and stuff like that, gnat catchers and those kinds of things. I think it doesn't hurt you to disclose stuff, but clearly some of them that I've read these things, listen, do you want to buy the house? You certainly know everything you need to know. Okay, everybody good with that? Okay, so I counsel our sellers not to use the form, not to fill the form out. Let's get a third-party provider to do it. Some of them have amazing E&O insurance. Let's get a third party to do it. Take the heat off of you. You don't know. I don't know. I can't tell you. Even if I knew, I couldn't tell you, right? Okay, so bottom line is, it's the law, and it's a statutory disclosure, which means the buyer's got 3 days to rescind, remember, unless you give it to them at the time of the offer. So my advice, get it at the time of the offer and give it over to the buyer. Okay. All right. Questions on any of that? That's one of my, that was just one that just came up one day, and all of a sudden we're dealing with this natural hazard disclosure. And I get it, believe it or not, you get somebody moving here from Pennsylvania and they said, they buy the house and they come back later on and they say, oh, I didn't know you had earthquakes in California. Are you kidding? Right? Guess what? You have earthquakes in Pennsylvania. Okay. But you know what? Now it's just a way to make money. So let's take that away from them. Okay. Which hazard disclosure company do you generally use? So Betty Ann, I've said before, you can never answer the question, who should I use? You can only answer the question, who do you use, right? So I have companies that I like to use. I have one company in particular that I use in pretty much every transaction I do. I mean, I've rarely ever had it done differently. Sometimes agents will shop companies based on price. There's always something, guess what? They're shopping you on commissions, right? So, you should be cautious about that. But, I'll get a counter offer over, the property ID versus disclosure source, and the difference is $35. And it's like, we're doing $1 million transaction. You're going to argue over $35. Well, you think you're looking like a hero to the seller? I don't get that. So, I don't know. I have my own personal preferences. I don't like a la carte. I like, just give me the big package, right? I don't like, having to pick which ones, because you know what? I'm going to miss something, right? It's kind of like having a seller investigate the property for termites at the time of the offer, or the time of the listing, and then the buyer comes back and says, well, why'd you stop there? Why didn't you investigate all the other stuff? You could have done an electromagnetic fields. You could have done, manometer readings. You could have done a geo. Why'd you stop with the pest inspection? Why didn't you do a physical inspection? So, I avoid those kinds of things by being professional about what I do. So great question, Betty Ann. Thank you very much for that. Okay, so let's take a look now. I'm going to clear other questions. I'm sorry, other questions? Waiting for Betty Ann to come back and say you didn't answer my question. Okay, all right. Okay, so let's take a look at withholding taxes. I'll talk to you offline about that, Betty Ann. I have one. Yeah, I think, I'm doing well over 100 transactions a year. Well, God, more than that. But every single one of them, I get all my services. I rarely ever have to deal with anybody else's stuff, because it's usually the third party that creates the problem during the transaction. So I'm just kind of like a mini control freak. But I've had agents say to me, we love doing real estate with you because, we just sit back and wait for our check to show up. And it's like, well, I don't know if that's a good idea, because you're supposed to be representing your client. But yeah, I'm probably going to get you there with a minimum of hassle. Okay, so let's take a look at my withholding taxes. So within the time specified in paragraph 14A, remember seller's time period, 7 days, okay, to avoid required withholding, okay, because it is the law in California, okay, seller shall deliver to the buyer or qualified substitute. Okay, so who's my qualified substitute? Usually the person like the escrow or the title company, qualified substitute, an affidavit sufficient to comply with federal FERPTA, and guess what? There's also a California withholding law, and that's going to be my AS or my QS. So my AS form is part of the FERPTA that you normally used to see. They used to be on the same form. Now we've bifurcated them. That's a big legal word. We've bifurcated them. So, now, you're still responsible to do the FERPTA, but we're usually going to pass off the California part by doing the qualified substitute. We had a big fight with the escrow companies. We don't want to be, liable for any of that stuff. Well, they had to collect the information anyway, right? They had to get a statement of information, a statement of identity of the parties. So why don't you just collect the information? Just tell us you got it. And that's kind of what that boiled down to, okay? So federal FERPA, so remember in the country, the law changed January 1 of last year, where the withholding, if they're not a U.S. citizen, the money's going off out of the country, then 15% withholding of the gross sales price. For California, if you're not a resident of California and the money's going to go someplace else off-site, it's going to be 3 1/3% of the sales price, or 9 1/3% of the profit, or whatever revenue the seller is going to get off of that. So provide the form. And if you can't provide the form, remember that you as the agent are in the food chain for having to pay the tax if it doesn't get paid. So just make sure you're aware of that, and monitor the situation, and make sure you use good third-party service providers that are also doing things to kind of make sure that you are protected as well, okay? Make sure you get that QS form. No questions on any of that? Oh my God, where does it go? When I teach my law class, which is going to start in about 2 weeks, and again, it's continuing ed for attorneys, and they just wonder how we do so much stuff in 3.5 hours. It's amazing the amount of stuff, and we're not done. So it's a lot of really cool stuff. This is job security for you and me. I don't want anybody to be intimidated by any of this, because you folks that are here today that are doing this know more than most any real estate agent that's out there. All that other stuff is fluff. Let's know what we're doing, okay? Megan's Law database disclosures. So there's this little law, okay? It's a big deal, all right? In California, it has swept the country, okay? Tragic event. They created the need, the legislative need for a database. And so what happens with this database is they have a database that has known registered sex offenders. So known, registered, not all of them registered. There are sex offenders out there that are not registered, but the state of California they required themselves to create a database. When it first came out, you had to go down to the sheriff's department. They had a book, you go through the book, and oh, by the way, they registered you for coming down to look at the book. So it's not like, you became a registered sex offender, but you became registered as someone who came down to look at the book. Okay. So now today, the law requires that the DOJ actually have a website, and that's called meganslaw.ca.gov. And so your obligation as a real estate agent is to disclose the existence of the website. It's open to the public. Anybody can go in there and look. My advice for us as real estate agents, my non-legal advice is I would never go to the database. I've never been to it. I've seen pictures on the telly about it, but I've never gone to the database. I'm not going to the database. And why won't I go to the database? The reason I won't go to the database is because I will be held to have constructive knowledge of everyone who's in the database at that time that I did it. So if I go in today and I sell a house 2 weeks from now, and it turns out that the buyer doesn't go and look at the database, and they say, how come you didn't tell me about this guy? This is their attorney talking, by the way. How come you didn't tell them about the guy living next door that was on the database? And it's like, I didn't know. Well, you went to the day. When did you go to the database? Well, 2 weeks ago. Well, he was there at that time. He or she was there at that time. Why didn't you tell the buyer? Do you understand what I'm saying? And this is stuff I deal with in court. Okay. So my little sister, I sold her a house. She goes, my sister, I love my sister, right? She worked for the city at the time. And she literally calls me up before the transaction closes and says, I went to the database. And I go, well, that would be like you to do that. She doesn't do real estate, but she went to the database. She looks everything up. And she calls me up. She says, I went to the database. The two guys next door are on the database. I go, you're kidding. I had no idea. She says, I know you don't, because you never went to the database. You said you weren't going to. It's my job to do that. It's the buyer's job to go to the database, right? So they go to the database. She goes to the database. There they are. My sister doesn't have any children. And this is my sister talking, so I'm not going to take a position. But I asked my sister, so what do you want to do? She says, well, what can they do? It's me and the husband, and we've got 3 dogs. We're not going to worry about these guys, and that's going to be her decision. I mean, sometimes that can go bad. Well, it was funny because they bought the house. A week later, these guys moved out, went off someplace else. Do you have to disclose, if you have to know that someone's on the database before you have to disclose it? But I'm going to tell you, I don't go to the database, so I don't know, and I don't have to disclose rumor or conjecture. Okay, all right, everybody good with that? But it's a serious issue. Okay, but I don't go to the database, so nobody's ever going to be able to pull me up on the stand and say, "How come you didn't tell them this? You went to the database." I don't go to the database. I'm not going to. Okay, so depending on an offender's criminal history, this information will include either the address. Nowadays, I think you got pins and maps and stuff everywhere. Okay. All kinds of fuss every time one of them's going to get released. I know some of our elected officials, I don't call them representatives anymore, our elected officials, get in all kinds of trouble because they're being dumped in my backyard kind of thing. It's like, God, you ever looked? I mean, it's a lot more than you think. Okay. So zip code in which he or she resides. Neither seller nor brokers are required to check this website. Take that to heart, folks. If the buyer wants more information, broker recommends the buyer obtain that from the website during the buyer's contingency period. Okay, so 17 days or whatever you've agreed to. Brokers do not have expertise in this area. I don't know. Okay, I love saying I don't know. I know the appropriate time to say I don't know, and you should get that in your vocabulary. You should be able to say I don't know. So what I usually say, and it won't apply here, I usually say, that's a great question. Let me find out, and I'll get back to you. And I've said this to you probably 20 times in the last couple of weeks. That's what I always say. In this situation, I'm going to tell them, you're going to have to go look at the database and look for advice. I don't know. Different people have different criminal histories. It's important. Okay. All right. Everybody good? Questions? Seeing none. Let's take a look at E. Look at the time. Notice regarding gas and hazardous liquid transmission pipelines. Oh my God, created a huge thing. So, in our risk management community, we have probably 26 of the brightest real estate attorneys in the whole county, right? We got some of the biggest brokers in town. We got a lot of little brokers in town. It's a pretty impressive committee, difficult to get onto. I don't know what, I think I'm there because I proof things. But, this came out where they said, we're going to make it so you must disclose the location of these lines. Now, how would you feel if you knew that there was a 12-foot wide gas line running down underneath Rosecrans? How would you feel about that? Would you take a different route next time? And so on the committee, we felt, now you shouldn't really be doing that because you know what? You're opening this thing up for terrorist activity, for all kinds of things that can happen. The legislators went through with it anyway, and so boom, we have to make the disclosure. So here's your disclosure. Notice is being provided simply to inform you that information about the general location of these lines is available to the public via what? Here's the website. Okay. To seek further information about possible transmission lines near the property, you may contact your local gas utility or other pipeline operators in the area. And again, that's supposedly to protect our safety, but we may be actually opening up a Pandora's box, as we say. Okay, all right. So you are required by law to make the disclosure. Make the disclosure. You don't need to. You're not required by law to comment on it. Okay. All right. Let's take a look. Let's move forward. Oh my God, I will never die. I have way too much paperwork to do. Okay. So let's take a look at F. All right. Gosh, nobody's leaving. So apparently I'm doing pretty good. So here's F. This is my condominium planned development disclosures. Now I want you to remember planned development, you know them as PUDs, planned unit development, things like that. Remember anything that's going to have a CC&R on it and have a homeowners association. It doesn't have to be just a condo, but anything with features in common with others. So for example, a pool, a gate around the entire community, guards, anything that everybody's going to be expected to pay for a piece of it, right? So maybe I'm paying, $200 a year, but everybody's paying $200 a year to get $200 a year. Like most of these are what, $600-700 a month to cover the guard that's there, whatever. But I'm able to dissipate that cost. If I had to hire them myself, I'd probably pay a lot more. So we're going to make this something that's forced on everybody. And that's the issue. The issue is we need to tell the client when they're getting involved in an area that has features in common with others, and that they're going to be paying for these things. And you know what? I always tell you, I get on every homeowners association I've been president of 3 of them. I mean, because nobody else wants it, right? But let's take a look at it. Seller has, I'm back to 7 days again after acceptance. So 7 days is that magical number. So Pamela, was it you that said 7 days is my magical number? I want the seller, I want to have everything in my hands when that offer comes in. I forget 7 days, I'm talking about 0 days. I want it all to go over. So to disclose to the buyer if the property is a condominium or is located in a planned development or other common interests, and I'm going to do that with my SPQ form, okay? And if the seller is otherwise TDS exempt, I'll do it with my ESD, okay? All right, so make sure that those disclosures are made. And again, the SPQ form is a great little form. It just drills into the question. SPQA makes it even more exciting. Remember, this is the state form, so therefore they're only mentioning the SPQ. In paragraph number 5, I check the box under A and I put CAR forms, APA, LAD, and SPQA. That's in my template. So if you've asked me, I can't see my email right now, but if you've asked me for my template, I'll send you that, and then you can do whatever you want to with it. It is obviously not to substitute for the advice of your broker, et cetera, et cetera, et cetera. I think we talked about all that. Okay, all right. And then finally, oh man, we're not going to make it. Okay, finally, yeah, it's not like I make stuff up, right? I mean, all this stuff is really good. It still takes, I still need more time. So let's take a look at paragraph here. If the property is a condominium, whoops, what happened there? Oh, don't do that. If the property is a condominium or is located in a PUD or other common interest subdivision, seller has 3 days. Now, how many times have you seen the seller request from the homeowners association the documentation within 3 days? Usually you get it like 2 weeks later. It's usually the escrow company that orders it because they know that the seller was supposed to and the seller didn't. So as a listing agent, you might want to do that. I personally don't, and I'm going to tell you why. They have a form HOA1. Here's the thing. In most cases, the lender is going to require a certified copy, okay? So a condo cert, for example, much like they want certified escrow instructions. So me preparing all that stuff in advance isn't going to work. So why don't you call your listing agent? Why don't you call your favorite escrow company and have them order it, have the seller pay for it, and have them order it in advance so that you have it at the time of the offer, okay? Remember, I'm going to be in that statutory area. The buyer's entitled to that information. Number 2, copies of documents required by law. So that's going to be Civil Code 4525, right? So a lot of times these HOAs create this great big, it isn't the HOA, it's the property, it's the management company, creates these big packages of stuff that include not only stuff that was required by Civil Code 4525, but also other stuff. And then you get this bill for like $800 when it should have been just $200, but they threw all this other stuff in there. So the contract says, and again, this is my RPA, contract between the seller and the buyer, copies of any documents required by law. So only do the ones that are required by law. The buyer can pay for the other ones. And that's what your contract says in your RPA in 7D 3 and 5, right? Okay. Disclosure of any pending or anticipated claim or litigation by or against the homeowners association. So you know that when you get the condo cert, you know it's going to tell you whether or not there's any litigation. I mean, I sold a home in Cardiff Cove off of Manchester and I-5, townhome. I'll never forget it. And the it was a hawk just went by my window. So I'm looking at the the financials of the homeowners association. I see, legal fees, $200,000 a month. And I go, are you guys in litigation? And I contacted the listing agent. They weren't aware of it. They contacted the seller. The seller wasn't aware of it. Contacted the HOA. And they said, oh yeah, we're definitely in litigation. It's like $200,000 a month. Yeah, you are. Okay. So, but today it's a little more obvious than that. But back then, boy, you had to look for stuff. So number 3, a statement containing, now I got to get rid of some of my stuff here. A statement, number 3, is a statement containing the location and number of designated parking and storage spaces. I mean, how many times you do a transaction and, it's like, figure it out, right? No. We want to have that stuff. Copies of the most recent 12 months of HOA minutes, or regular and special meetings. So that came up in a lawsuit for me almost a year ago, where the minutes of the meetings talked about the construction that was going on in the community. Buyer said, I didn't know anything about any construction. They're in the minutes. So you want to make sure that you get all of the most recent 12 months. Sometimes, you always ask escrow to send you a copy of stuff, but, they missed April, and April was the hot month, right? That was the month when all the bad stuff happened, okay? Number 5, names and contact information of all HOAs governing the property. And it says all. So, for example, in Carmel Valley, we have multiple HOAs. You have a master homeowners association that handles those common areas that are on the main streets, like the corner of El Camino Real and Del Mar Heights Road. All 4 corners are maintained by the master HOA. Okay. And so guess what? You're paying, I don't know how much it is. I think it's $30 a month or something in your dues. And then I owned a lot of property there at one time. And in Cambria, I was paying $185 a month at one time for the HOA dues there, and then another $30 for the other HOA dues. So remember that there's not necessarily only going to be one homeowners association. So we need the names of all of them, contact information. Okay. Private transfer fees, if any. Okay. Number 8, pet fee restrictions. Number 7. Number 8, smoking restrictions. Smoking restrictions are enforceable by law. Certain types, are enforceable. Okay. Let's go on to the next field here. Sellers shall itemize and deliver to the buyer all CI disclosures. Okay, so CI is, again, common interest disclosures. Okay, received from the HOA and any CI disclosures in the seller's possession. So, I've had agents say, well, seller is a flipper. They just bought the property 3 months ago. We're just going to give you the stuff that we got. That it does not satisfy the contract, does not satisfy the statutory intent. You want to get the most current ones. I'm sorry, you're going to have to pay $50 and get one from the HOA, get a condo cert. All right, don't give me the stuff that you get. I had a seller once, we got it 20 years ago. Here, you can have what we got. It's like, no. A lot has happened in 20 years. Okay, all right. Buyer's approval of those disclosures is a contingency of this agreement, and it says so in paragraph 14B3. Okay, so it is a contingency. It's very important. Don't let anybody talk you out of that, okay? Again, unless it's your broker or your attorney. Okay, the party specified in paragraph number 7, as directed by escrow, shall deposit funds into escrow or direct, and again, 7 is going to be what? 7D, where the money, who's got to bring in the money to pay for this stuff. Seller doesn't, we've made it by contract that the seller is going to do certain things, and then there's other parts that say that other people can pay for it, but it still has to happen. Okay, all right. Designated with shall deposit funds into escrow or direct to the HOA or management company to pay for any of the above. So you need to get those things ordered. How much time you have? You've got 3 days. Okay, from the time of the listing. So, from the time of the contract. So remember, offer, acceptance, delivery to the party to be bound. You've got 3 days. Okay, so boy, we covered a lot of stuff. Thank you all for being here. I wish you the very best. Take care for now.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.